Can a local municipality transfer authority for police disciplinary action from a collective bargaining agreement to a locally controlled police accountability board? To find out, you have to read Rochester Police Locust Club versus City of Rochester, but it's 38 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Rochester Police Locust Club versus City of Rochester. The citation for this case is 2023 New York Slip Opinion 05959, published by the New York Court of Appeals on November 20th of 2023. The issue in this case is whether a locality, Rochester, can transfer police disciplinary authority away from a collective bargaining agreement and to a local board, a police accountability board, composed of 9 citizens of Rochester. The background law that I think is helpful to understand this case is a couple of things. First, there's something called the Taylor Law in New York. The Taylor Law is a statutory expression of the general preference that disputes between public employees and the government should be resolved via collective bargaining agreements. In New York, public employees are not allowed to go on strike. And if there's a dispute about the terms of employment, the conditions of employment, disciplinary actions, those are all subjects that have to be collectively bargained. The other thing you have to understand is that Civil Service Law 75 and 76 is a statute that describes in New York state law the procedures and the rights that must be applied if police are going to be investigated, disciplined, or removed. It provides a whole host of different rights, including that police cannot be removed or disciplined until there's a hearing, upon notice, with due process, the right to counsel, a variety of rights they have. Now, obviously, some places when this was passed, there was a conflict between Civil Service Law 75 and 76 and all these rights, and also what localities might have had. And basically what the case law has held is that if localities had legislation that placed the authority for police discipline in the hands of the locality, in the hands of a local officer or official, then that would be grandfathered in and would take precedence over the collective bargaining requirements of Taylor Law and Civil Service Law 75 and 76. It would take precedence if it was grandfathered in. And the last thing you have to understand is that there's something in the New York State Constitution and statutes called the Municipal Home Rule Law. And that says that localities are allowed to make their own rules that could be different from other localities, but cannot be inconsistent with the state law. If the state says it has to be done this way, then that's the way it has to be done, and a locality can't change it. But as long as the state hasn't spoken on a specific area and preempted it, then localities can make whatever laws they want that are not inconsistent with other laws. Okay, what are the facts in this case? The facts are that the city of Rochester has a long history. In 1907, the city charter of the city of Rochester placed the authority for police discipline in the hands of the Commission of Public Safety, in a local official. That precedes the Taylor Law, and it precedes the passage of Civil Service Law 75 and 76. So it's grandfathered in. And then in 1985, they passed a law removing that protection, that grandfathered provision, and said, we're going to take it out of the Commission of Public Safety, and it's recognizing that it's part of it's already covered by Civil Service Law 75 and 76. So they basically took it out of that grandfathered provision and put it into the hands of collective bargaining, where it's been since 1985 until 2019, when in 2019, the city council for Rochester, the mayor, and 75% of the citizens in a referendum said, we don't want it to be in the hands of the police anymore. We are going to create a police accountability board made up of 9 citizens of Rochester who will have exclusive authority to investigate and discipline police officers for misconduct. At that point, the Rochester Police Locust Club, which is the union that represents the police officers of the city of Rochester, sued. And they sued in Article 78 saying you have no right to pass this law. It's a subject exclusively of collective bargaining because of the Taylor Law, because of Civil Service Law 75 and 76. And the appellate division agreed. The appellate division said the city was obligated to negotiate with the union on the issue because it was part of the CBA, the collective bargaining agreement, since 1985. The city council then appealed to the Court of Appeals. And here we have a majority, a 4-person majority and a 3-person dissent. The majority basically says this was grandfathered in and therefore removed from the collective bargaining requirement, but until 1985. In 1985, they removed it, and now it's subject to that municipal home rule. And the municipal home rule says it can't be inconsistent with the state law, and the state law says collective bargaining. The Taylor Law, Civil Service Law 75 and 76. So at this point, they can't go back and make it subject to a local official. That would violate the municipal home rule because that area of law is already preempted by those statutes. But interestingly, there's a very strongly worded dissent, interesting dissent by Judge Wilson, joined by Judge Rivera and Judge Halligan, that says municipal home rule law does not just say that it can be preempted by state law. It says a local law is not allowed if it conflicts with state law or state public policy. And there's a strong state public policy that favors strong disciplinary actions against police officers. So they say that just because there's Civil Service Law 75 and 76, don't ignore the fact that there's this movement afoot that wants localities to have authority over police disciplinary procedures and removal of police officers that have done misconduct. So Judge Wilson makes a very interesting analogy. He says it's like a one-way ratchet. The majority is saying that a city can only move from local authority to collective bargaining, but not the other way around. And he criticizes that. But once again, the majority holding here, what's controlling in this case is that because they removed the grandfathering provision, now it's subject to the rules of the Taylor Law and Civil Service Law 75 and 76. It is exclusively a subject of collective bargaining agreements. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.